Hello and welcome everyone. Welcome to this edition of GDPR at 7. Well, it seems like it was only a few days ago that we were talking about how GDPR will come live tomorrow, what will happen, will the things be okay? And we were talking that sun will still shine and everything will be fine. It so happened for 7 years and nothing changed. But we've had a few fines, we had a few challenges, we have had a few good, bad, ugly, all those things. And now it's time to say what went well, what can we improve, and what can we look forward to. Because compared to 7 years ago, nowadays we are using some new words like AI, like quantum, like emerging trends, or even the word trust is coming up. So, to discuss all this, what I have with me is three interesting panelists, and coincidentally, not planned, they are also ladies. So, you cannot say she leads tech and all that. It's full women empowerment. So, let's get started to look back and look forward to 7 years of GDPR. And I welcome my fellow panelists, and I also thank them for being here. And at the same time, I also thank everyone who has joined live with us. So, thank you so much. So it's great to have you, those who have registered, those who have joined, and those who will be joining. Everyone, thanks and welcome. And let's get started. My name is Punit Bhatia. For those of you who do not know me or who are seeing me first time, I'm a privacy and AI expert. And like my fellow panelists, guide people on complexities of compliance with EU GDPR and EU AI Act. So, why don't we get started with the introduction of my fellow colleagues? And may I ask, and as I ask my fellow colleagues, I think to make the introduction a bit more interesting, I would also ask them what comes to their mind when they think of GDPR. And usually I am used to asking that question in one word, but here we'll be asking that in one sentence. So maybe if it's okay, Dr. Carey, we start with you. Introduce yourself and tell us what comes to your mind when you think of the GDPR.
Certainly. Hi, everyone. Thanks for having me. I am Dr. Carrie Miller. I am in the US, so I am envious of GDPR. I am the head of AI governance and research at the Center for Inclusive Change. I am also the executive director at the AI Procurement Lab. So when I think of GDPR, I feel like it was the big bang moment of data protection for consumers, a big, huge awareness moment for data protection in general. And the rest of us use that law as a follow the leader kind of a situation. So it was the pinnacle moment for all of us.
Interesting. Uh, so, would you also want to share a bit about you, or you
Um,
think that's enough? I mean, up to you.
oh, you're going to hear enough from me later. We can move on.
That's good. That's good. So that's good. GDPR was about awareness and the pinnacle moment, and it's good that somebody sitting in the US says that they're envious of the GDPR. Because I would also at a later stage like to ask you, how do you see sitting from there a bit far? Because we are sometimes too grumpy about what it does and what it doesn't do. So with that, thank you, Carrie, for what you shared with us, and may I move to Heidi to share with us about herself and her view on the GDPR.
Yes, of course. Thank you, Punit, and thank you for having me on this interesting panel. So, my name is Hedy Waam. I'm a partner at DLA Piper in Brussels, where I'm heading the data, digital, and cyber team. And we offer our clients the full range of assistance, going from compliance advice over strategic advice, litigation, and cyber assistance. So when I think of GDPR, for me, I think mainly about the fact that it's a really powerful instrument, by the fact that it gives the vulnerable people, the data subjects, so many rights. As you all know, there's a series of rights for data subjects, which gives them control over the data that is processed, over their digital trail that they leave when they wander around in the online world. But then also at the same time, putting obligations on the more powerful, so to say, on how they should deal with data and laying down the relevant principles. So that's what comes to mind with me when thinking of GDPR.
Thanks and welcome, Heidi. I think very well said. Obligations for the powerful and rights for the vulnerable can't be summarized more succinctly. So we move on to Valerie. Valerie, tell us about yourself.
Hi, Punit. My name is Valerie Lyons. I'm Chief Operations Officer in BH Consulting. I'm also author of the Privacy Leader Compass. And I also do a lot of work for Cyber Ireland, for the UN Internet Governance Forum, and I'm on the pool of experts for the EDPB. I suppose my background is primarily was originally cybersecurity for many years. I was the former CISO in KBC Bank in Ireland. And the last decade, just over a decade, has been mainly in privacy and more recently in AI governance. So I think I'm a bit like the human version of ISO. I seem to have a little extension into everything. But that's me. And then the question, I think, is what comes to mind with GDPR. I see it as an instrument, essentially, that forced organizations to think differently about data and to move away from data as a commodity to something tied to dignity, to autonomy, and mainly to consumer trust, which is essentially what my PhD research it was into privacy and its influence on consumer trust.
Perfect. So that's wonderful. Thank you so much, Valerie, and welcome. Yes, it's an instrument that actually, in the end, enables trust or creates trust. And for those of you who are live with us, you can share your question in the chat and we will do our best to answer your questions. So please do that. And if you can also share while asking your question, which city are you joining from so that we can know where we are live as well. Now, you shared what comes to your mind when you think of GDPR, but I'm also interested and I'm also curious to know what has been the significant challenge that kind of remains after the 7 years. I know some of us will argue it's 9 years because the GDPR came in and there was a 2 year period for us to comply. So seven, nine, whatever, doesn't matter. But what is the one significant challenge that still remains? And in this case, maybe if I ask Heidi, you start first and explain us your view on the biggest significant challenge.
Yes, thank you, Punit. I think one of the, maybe not the biggest, but one of the bigger challenges for me is like embedding it in the organizational structure and in particular the position of the DPO. I see that many companies still struggle with that. The DPO has a very unique position, as you all know, with very specific tasks under GDPR. But at the same time, we see that within companies, the DPO is really seen as like, yeah, the key data protection person and everything that relates to data protection goes to the DPO. While there, you have then often a tension that the DPO is asked to take upon him or herself more operational tasks that normally lie with the controller. So that remains often a challenge. And I see also that for DPOs, it's not always easy to push back on that or to make the organization understand, like, okay, there should be a clear distinction. It, of course, also has to do with resources. I think in general, resources is a challenge linked to that, that the company thinks, yeah, but we have this DPO, you're paying him full time, so why can't we give everything to the DPO? So I think that remains a challenge. And also seeing that the DPO is often required to take upon him or herself additional tasks. For example, in Belgium, you have the Private Investigations Act that lays additional tasks with the DPO. You also see that in the context of AI, companies are, depending on what legal support they have, that also want to lay tasks with the DPO. So I think that that remains a challenge, and then linked to having sufficient resources to really embed compliance within the organization and going past a tick box compliance exercise.
Absolutely. I think I would echo that view, and perhaps the fellow panelists also, that embedding is always a challenge because it's a complex task. And the DPO position, whether by law in the GDPR or even in the places like US where you do it voluntarily, it's not easy. In fact, I was reading a state of privacy report, the global state of privacy report for this year, and about 50% people say that they are not adequately staffed and they don't have adequate budgets. So yes, that remains a big challenge. And I'm also curious, across the Atlantic, Carrie, how do you see, or what challenge do you see even after these 7 or 9 years of GDPR?
Yeah, it's really interesting because when GDPR first started, our biggest challenge, I was working in e-commerce at that time, and we were mostly concerned with transactional data, across the pond, and how do you delete me, and trying to figure out, we legislation kind of can come together and rub together as friction points where they don't agree. So there's retention rights that companies have, and then there's rights that consumers have. And so trying to navigate that feels so simple now, 7 years later. That was child's play compared to where we're at now, because your data was relatively structured. It was identifiable. It was relatively labeled back then. When I think of what we're dealing with today, the complexity of trying to track data in unstructured ways, and its voice and its visual, and it is monumentally challenging right now to keep all of your data tracked and all of that stuff. And on top of that, then you have the legality of, did you even collect it appropriately to begin with? So I think the difficulty and the complexity of where data is at today is probably the biggest challenge I see from my vantage point.
No, that's also agreeable because data is everywhere, and which of that is personal data and where is it? And thankfully, the GDPR asks you to make a records of processing activity. I call it the data inventory because if you don't know where your data is and what data you have, you cannot start any kind of compliance program on data.
But
Uh,
the other challenge is that it's across controllers and processors, and then they have processors, and it's the network that's a spider web situation that's adding to the chaos.
Absolutely.
Yeah.
And I think in the modern world, it's very difficult to say data is with controller or with processor because it keeps flowing. I mean, of course, there's the data in the database and the systems, or the when we say files, but the data is also, like now we are talking, our voice is personal data, and it's traveling, I don't know where and which server and which location. So it's very difficult to pinpoint where the data is and what it is. And that makes me think, what would Valerie say about the significant challenge, because we've said so much.
So I think GDPR gave us the what, okay? It gave us data subject rights, it gave us lawful basis, accountability, but it struggles with the how, particularly in complex emerging systems that we have today. In other words, the how to deal with, say, generative AI and purpose creep. It doesn't have the ability to deal with the how there. If I look at recent case law, we'll see the Dutch childcare benefits scandal, famous in Europe. While it wasn't unjust in how it was developed and distributed, it was unjust in its outcome. So GDPR failed to account for the unjust outcomes. Now, I know the AI Act comes along then, and it certainly helped. But that was one of the key challenges that I think we're only beginning to see now. And that goes hand in hand with that is the inability for enforcement, the teeth that came with GDPR. One of the strongest measures actually that came along with GDPR were these teeth, because I remember the previous data protection commissioner in Ireland, had no teeth. Billy Hawkes was his name, and he never had the ability to fine or to do anything else. All he had to do was to try and do things through reputational communications and brand damage. That was all he had at his disposal. Now the DPC and the other supervisory authorities have got teeth. But those teeth, the only teeth that we're seeing used, with the exception of Garant, with OpenAI, with the disease processing orders, those teeth tend to be fines. So we're seeing fines in the DPC over $500 million. That is how big these fines are. And yet we've only received 1% of fines. So enforcement is really not going to rate, I think, going forward. It's the biggest challenge that GDPR has, is that the only way to stop the current trend, which is organizations saying, well, we'll just seek forgiveness rather than ask permission. We're just going to go ahead and do it. Then they're going to fine us, and then we're going to take it to court. We're going to appeal, and we're going to continue to do what we did always for the next 3 years while we drag them through the courts. That's what essentially it's looked like for the past 7 years. And so I don't think that's going to work, because then our data will be used to train models. So I think we need to look at enforcement orders as a big part of the future, because of the weakness of the past.
Okay, so according to you, the consistency around the enforcement has been a big challenge. And that is perhaps a very good segue for me to say, our colleague outside of the EU, how does she see? I mean, I'm talking about Carrie. So I'm curious, when you are in the US, how do you see, especially from a distance, has there been a fair amount of reporting on compliance failures over the years? Have there been enough fines, or maybe talk about some patterns, some trends as you observe from across the Atlantic?
Yeah. So one thing we've observed is the pattern of who's bringing enforcement matters to the attention of the authorities, and it happens to be privacy groups. They tend to be the watchdogs. So that's great. Keep up the fight. Thank you very much. And then the pattern of like, what are we going after, or what seems to be hitting the radar? Data security failures. Surprise. Unlawful data processing, so where there's no legal basis for collecting the data. Violations of data subject rights, which is sometimes hard to do, but nonetheless, especially for small, medium businesses. And transparency failures, and then just your basic governance and accountability failures of like, you didn't have a process, you didn't have a policy, you didn't have a DPO, basic stuff. But the big ones are the data security failures and the unlawful processing. And what's really interesting about the data security failures, and Valerie can probably speak to this until the cows come home, a lot of it's human error. A lot of it is the same stuff we see without GDPR. So it's like we've never learned our lessons, on a misdirected email or an unprotected file. So for some reason, we just keep learning those same security lessons. And then the legal basis is, data is gold, right? So everybody wants all of it, more of it, as much of it as they can get their hands on. It's like, that's a problem. Because, by the way, go back to number A, security failures. So the more data you have, the more you're exposed, the more problems you're going to have. So data minimization is something we really need to start thinking about. It's counterintuitive for businesses that run on data is gold mentality. That's something we are really going to be wrestling with over the next, 5 years or so. How much data do you really need to get done what you minimally need to get done? What are you really doing here?
Yeah, I think you touched upon almost everything in the GDPR, all the principles, I would say. But yes, in each and every principle, it's always very challenging for people to implement, and that remains a thing. And there have been a few investigations in that sense, in fact, on all those topics in the past, and there have been some DPAs who have initiated those investigations either based on complaints or on observation, and there have been a few fines also. uh, I mean, from where I see in Ireland, and from Ireland would see in Italy, and but across Europe, many fines have been there. And I'm tempted to ask Heidi. Heidi, you are helping sometimes companies or representing clients before the DPAs, especially when complaints are coming from the data subjects and resulting from insufficient or ineffective, or what would I say, unsatisfactory application of principles or the basic principles that Carrie was talking about. So, what type of practices do you observe in this market, especially the EU? And what can companies, I mean, I'm combining a lot of questions maybe, but what
Go
can
ahead.
companies do to be less exposed to this regulatory scrutiny? So, what do you observe, and what can be done to limit this scrutiny?
Yeah, thank you, Punit. So observations in terms of enforcement, it's indeed very much complaint based. There are a few regulators, and in a few instances, they do what I would call more proactive enforcement, but most of the things are complaint based. And there, I'm always surprised to see like how many people take the time to file a complaint. Honestly, often also without first exercising their rights with regard to the control vis-a-vis the controller, or first talking to the controller. So like immediately a complaint with the regulator. I don't think it's very helpful, but it happens. What I also see is that many complaints, there the complainant is not really so much concerned with data protection, but it's more of a means to put pressure on the controller or to obtain something to use in another discussion. So we often see it in employee disputes, where someone is licensed, or where someone feels like, okay, I'm gonna be licensed or so ever, and that they start like with these data protection um, requests and then filing complaints. And I find that a bit a pity, because yeah, it's almost a bit of an abuse of the rights. But yeah, abuse of rights is always hard to prove, but I find it a pity. It's a bit misused, I must say, in practice. Of course, also some activist type of complaints, as we have already discussed. So yeah, there's a bit of everything. I do note, and especially in Belgium, that many complaints are dismissed. So there, I think there's still a way to, yeah, to optimize the process, I think, because it's also frustrating. I can imagine for my clients, it's good, of course, if a complaint is dismissed, but I can imagine that for plaintiffs, it's also frustrating. So I think we have to find a way there to yeah, to address that in a better way. And the Belgian DPA is looking more towards like mediation, or like having a process really before the actual litigation. And I think there would be a benefit in there, and that they should pursue that more actively, and possibly also in the investigation phase. In Belgium, you have also, before it's the actual litigation phase, you can have an investigation by the inspection service. And there you see, and I find that really a pity, that often following a complaint, they do an inspection, but in many cases, they don't even get in touch with the controller. So they do some desktop review, they do their report, and it goes to the litigation chamber. And then as a company, you have to defend yourself immediately before the court, so to say. And I think there's a bit a loss of momentum there, because in the inspection phase, I think you can really have like a sensible and a valuable exchange with the controller. Because in many cases, I know there's some malpractices, and there's companies that want to abuse data, but in many cases, many companies, I mean, they just maybe they have been a bit careless, or yeah, they didn't think it through, but there's really willingness to enter into a discussion and to make things better. So that's a bit of a missed opportunity. And then to your point, yeah, what can companies do to be less exposed to regulatory scrutiny, there a robust data subject request procedure is really important. You need to respect timings, need to do it in a proper way, make sure that you duly analyze it, and also always treat it as a pre-litigious case. I too often see that sometimes when responding to data subject requests, controller get a bit carried away and they start admitting all sorts of things or apologies or saying like, oh no, yes, indeed, we've lost it and we're so sorry, or so things like that. But that is then often used in proceedings and it weakens a bit your position. So I believe to deal with all data subject requests, let's say, with this pre-litigious mindset, that can help a lot.
Okay, so you're suggesting that companies set up a data subject request process and also deal with it firmly rather than and with consistency rather than being casual about it. Oh, yes, we made a
Hmm.
mistake, and be apologetic. That's
Yeah.
interesting. But you also mentioned, if I may pick on something, that sometimes complaints are dismissed. And do you want to maybe add on to, from a data subject perspective, why are those complaints getting dismissed? Is there a validity? Is there the, you had mentioned sometimes they're using it for other reasons than data protection?
It's a variety of reasons. In Belgium, the authority has this dismissal policy where they look at the case, although they don't always rigorously follow it in practice, but it can be many reasons. It's because they don't have enough supporting evidence, or if it's clear that, for example, there's already a case pending before the labor courts or another court where they say, okay, no, but there's already something going on, we will not take it. Also, there's this the concept of like, is it of relevance for society? If is there a big societal impact? Sometimes they use that to dismiss cases to say, okay, no, but there's low societal impact, we will not do it. Honestly, I think it's also they have been flooded at a certain point with complaints, and there was a huge backlog. And then it was, I think, now already 2 years ago that they did a big dismissal exercise and that they dismissed hundreds of cases. So yeah, it's a variety of reasons, but not
Okay.
always consistent, because we have already dealt with cases that would, let's say, meet the criteria that they have in their dismissal policy, but nevertheless they pursued it. But of course they remain free to pursue it. But yeah.
So what I gather from this is then not only there's responsibility on part of the organization, there's also responsibility on part of data subjects when launching a complaint. And that takes me to something I read about Valerie's research, which is about power responsibility equilibrium, if I'm pronouncing it right. And that is about the perspective that there is needs to be a balance of power between data subjects and organization, and that equilibrium needs to be maintained. On one hand, the organization, now adding from my side, so I don't say that's a research, uh, because when you're in front of the person doing research, you need to be specific. So I'm adding from my side. On one hand, there is the power that the data subject has to raise request, but on the other hand, the organization also needs the data for certain legitimate purposes, and there needs to be that fine balance that needs to be maintained. And if I can ask Valerie, has the GDPR been successful or instrumental in bringing or rebalancing that power equilibrium that we talk about between the organizations and data subjects?
Yeah, of course it has, Punit. I mean, the power responsibility equilibrium theory, basically, it's grounded in the idea that where power is exercised, there has to be a corresponding and proportionate level of responsibility. So that organizations that exercise power in a responsible way, essentially it leads to sustainability. So you get like, short-term gains. If you maybe overuse your power, but if you're thinking long game, then you're thinking consumer trust, power responsibility, getting that equilibrium right. So the theory is not specific to privacy or data protection. The theory is just a theory that I applied in a novel way in my research, to try to develop an understanding, which is very kind of academic. That's what academics do, is they take a theory from one place and try to apply it in another. But if we look at the GDPR and the dynamics of GDPR, and sort of, first of all, it brings rights to the data subject. So straight away, we see the dynamic of power change. If you're going to give data subject rights in a time when they didn't have rights before. And so I see this, interestingly, a power dynamic at play. My partners from the US, when I have been presented with difficulties, a very famous example that I use for all my talks is COVID. If we remember, trying to get money back from airlines, I was able to use that data subject right to basically get me my refund way before anybody else did, because one might call it a misuse. You could call it a misuse, but at the same time, I have the right to ask for my information. And if you tell me that you're going to record the telephone call that we've made and you don't have a copy of that telephone call, I have the right to lodge a complaint about that. And that's what happened during COVID, is most of the organizations didn't switch over their call center to record the calls. They just sent the call center calls to people on their mobile phones. So we started to be empowered, not just from a data protection perspective, but also from a consumer protection perspective, being able to use this piece of legislation. But when we talk about the power dynamic, the GDPR actually did something else about the power dynamic that I think was really novel and really important. And it's not about data or do they collect our data. It's about how we classify data as whether it's sensitive or special category, or whether it's standard personal data, because we know that if it's special category, then it has to be treated differently. And so we know that if there is a power dynamic that pushes anybody into a position of vulnerability, then in GDPR, it's very difficult to use consent as the legal basis for processing. So a very good example of this is, and I've seen it happening in different jurisdictions, if I am an employer, I have the right to say to you, give me all your information. And I am so vulnerable because I'm a candidate, I have to do it because I feel so vulnerable. Well, GDPR says, well, actually, you can't do that. You can't just ask people for their information and process their information, because there's a dynamic at play here. So suddenly, organizations had to see if they actually had a legal basis to collect this information. Very good example of this is background checks. So we see a change in organizational behaviors when it comes to background checks. And now that empowers data subjects. And so there's so many parts of GDPR that affected a change in the dynamic of power, that I think it really achieved the power responsibility equilibrium, but not by the method in which the power responsibility theory is hoping it will, which is voluntarily by the organization seeking to establish longevity. It established this power responsibility equilibrium through legislation and law. So the end justifies the means, if you know what I mean, that you got to the end that is a good end, but not necessarily the way I would have liked it to have been, which is that organizations actually sought to do right by the data.
Well, that's very well said. I think it balances that power responsibility, but it also gives in a consumer dimension in which you may not have other means to challenge or ask for information, and then you can rely on these rights to ask that. In fact, I have used that many a times, because sometimes you really get stuck as a consumer. You have no means, you go to the privacy notice, find the DPO, send an email, and then things start to flow. So that's really true. But all this, the power responsibility equilibrium, the rights for data subjects, the obligations for organizations, that was meant to create trust, to enhance trust in the long term, and of course protect the vulnerable, as we call it. Now, when this trust concept, and that trust concept is also very central to the research you do, Valerie, so, and the work you do, so I'm tempted to ask you the follow-up question. So one of the reasons for the GDPR came in was trust. And more EU is coming up with even more legislations. I mean, we have the EU AI Act, we have the Digital Market Act, the Data Act, and so on and so forth. Because if we start, I will certainly miss a few. But is then this trust, when you look at it both from your academic hat and your operational hat in the industry, has GDPR in any way enhanced that trust, the consumer trust, I mean, in the organization's processing of data, or has it pushed the issue into more of the legal formality compliance checks wherein we say, I must have this, I must have that, I must have that? So, how do you see that trust playing in, especially after 7 years of the GDPR?
So trust is formulaic. It's very simply created. It's called the ABI of trust. So A is for ability, B benevolence, I integrity. So if an organization, and studies have shown us, if an organization consistently demonstrates ability, its capability of protecting your information, it does so in a way that's benevolent towards the data subject, and it demonstrates integrity in how it processes data, then privacy concerns will decrease and trust increase. That's what the studies show us. So do we think that GDPR had any influence on ABI, on our ability being consistently demonstrated? Yes, it did, because it forced organizations to have technical measures and organizational measures in place. So it forced those things to happen. Again, it's about, well, if trust is a byproduct of forcing those boxes that needed to be ticked, is it really trust? It is, because you're essentially developing trustworthiness characteristics through nothing more than compliance. So trust does get generated, and its intention was to increase trust. Let's not forget that it was a tool that was intended to increase trust across Europe, because trust made essentially business happen. So this concept of trust, it does come from the legislation. Should it? No, we should trust organizations implicitly if we knew that they do right by our data. The only reason we don't trust them is because they've consistently shown us that they shouldn't be trusted. But not all organizations. I mean, to be fair, there's a lot of organizations out there that are very compliance focused. If I think of the number of organizations that we deal with in my own organization on a daily basis, the only reason they're working with us is to ensure that they do right by the data, that they do this processing correctly, that they make sure that they adhere to the legislation that's applicable at the time. So trust does come from legislation. You may not like how it's achieved. You may prefer it to be achieved through naturally doing right by the data, but legislation is born out of violations of ethical values. That's essentially how it gets born. So it is part of the human condition, that, and part of market economies as well, that back to what Carrie was saying earlier, this concept of there's so much value in data that there's too much value for organizations, and they pursue that data at too great an extent. And so legislation has to step in. And we know that self-regulation doesn't work, because so many organizations have shown us that it doesn't work. So we have to have the legislation, and then trust ensues. But it's a false form of trust, no doubt.
No, I completely agree with you. It has been a means to create trust, and it has enhanced the trust. Now, how is trust interpreted? That remains subjective. Sometimes you say, I don't trust this organization in processing my data, but that is also enabling trust, because it's because of the GDPR now that you're able to say, I exercise my right, or I looked upon the company in view of the principles and the expectations and the obligations I have, and then I'm able to judge whether it's trustworthy or not. We do have a question from our audience, but I'll take it a little bit later because in I do have that also covered in the flow. That's around the efforts that are going around on the simplification of GDPR, but I'll come to that in a moment. Because at this moment, when we talk about trust, and especially since we talked about the challenges and what we think about the GDPR, I think what we are also observing is AI is growing more and more, or AI is coming in to the limelight or into the day-to-day work more and more. And AI is also complex. I mean, Carrie talked about the data being everywhere and the complexity of identifying where the data is. Now, in view of this AI and the complexity AI brings in, and I would even bundle in saying quantum as well, because that'll accentuate the problem many or times exponentially. So, what can an organization do in terms of taking some steps to put their best foot on GDPR compliance? Because whether quantum or AI or whatever emerging tech will come, the GDPR will remain in force. And of course, we always have two viewpoints: one saying, do I really need the new laws, the EU AI Act, and so on? And there's a school of thought who say, well, the GDPR is sufficient, there are principles, and we are covered. And there's another one who think we need other laws. Without getting into that, practically speaking, from GDPR compliance in the AI world or quantum world, what can be done additionally? And I'd like to ask you, Carrie.
Yeah, it is. It is the big question of the day. So I would start with, let me first say, I tend to come at this question from a business side as if I'm buying some technology. I tend to work with companies that aren't in a position to just build everything. So when you're buying these technologies, you focus on your procurement efforts and how you're going to bring this in. And my motto is, don't let the bad stuff in. Then you don't have a lot of the problems, right? So one of the first things you do is you start vetting your vendors to make sure that they have adopted privacy by design. And so you ask them questions. Tell me how you did data minimization. Tell me why you needed that data. Explain to me, what data you didn't use, because that's also very telling. And how you're doing data labeling, and show me your data flows and your traceability. And so you just kind of scrutinize a little bit before it gets through your doors. It becomes your problem. Beyond that, don't skip the DPA IA steps. Don't skip that data protection impact assessment step. Just build the muscle memory for that. Train your people, figure it out. It's not going away. Figure out how to do it. And if you can, it would also be good to go ahead and figure out how to do internal audits. If you are building, invite external audits to get yourself right. I mean, this stuff is not going away. It's getting more complex. You mentioned quantum. I'm more concerned with agents, because agents kind of like stack and layer these problems on top of each other. This stuff isn't going away. So the better you are at getting ahead of it today means tomorrow, when it's even more complicated, and next year when it's more, you're just better off. Don't delay. Now is not the time to kick the can at all. Even just a little baby step means you've taken a little baby step and you didn't delay. Just do something.
No, I agree. I think what you said are simple, basic steps. But even a concept like privacy by design, we've been talking for last 40, 45 years since it came into picture, and it's not done. I mean, I was reading some research, uh, and it said only 68 or 70% people are doing it. That means 2 out of 5 are still not doing basic stuff of privacy by design. And that's not even okay, the GDPR has made it mandatory, but that's some basic hygiene stuff that you need to put in place. Or the data minimization or the third party risk is not just about privacy, it's also about all other dimensions. But it's not happening. That you mentioned, put in some controls, get some audit done. But sometimes organizations are also scared of getting an audit, because then they will have findings, then they will know the risks, and then they have to act. So it's a chicken and an egg story. But while we talk about the chicken and the egg, I think the EU continues to adapt or adopt new regulations on data, on digital, on cyber, on AI. Talk about the EU AI Act for per se, talk about the NIS2 or anything else. So there is a complexity that's brewing up. So there was the GDPR, and with all these legislations, it adds to the complexity. And then the question is, how would companies navigate this complexity in this world? Because GDPR by itself was very, very, very complex. Let's not underestimate it. And it's still difficult to simplify it for stakeholders. So while companies are still struggling, they also have to navigate this regulatory landscape. So Heidi, uh, how can a company or how can companies navigate this compliance landscape, which on one hand continues to evolve, and on other hand, with the technology, more regulation is expected?
Yeah, thank you, Pun. It's a good question. I'll start by saying that it's not in any way an easy exercise for many reasons. If you see the EU Digital Decade laws, all the ones you've mentioned, and there are a few others, it's really making technology a regulated sector, which is kind of new. We know financial services as a regulated sector, pharma, and so on, but now it's also technology. So it means it has a really broad scope, and many companies that were before not regulated now see themselves in a situation where they can be regulated, or at least part of their activity. So that makes it a bit of complex. Another point is that the instruments, unfortunately, are not fully aligned um, with each other. So that's, yeah, you see that they have unfortunately been drafted in a kind of a siloed way. So there's concepts in certain acts that are used with a different definition than in other acts, and so on. So that makes it all complex. Also scoping, especially the data instruments, Data Act and Data Governance Act. For me as a lawyer, it's great because I mean, it's gifts that keep on giving. But you also have to think about the companies that really actually need to apply them in practice and need to do something with it, and that's much more complicated. And a final point on why it's so complicated, and then I'll say a word on how to navigate it, is that they are making also non-personal data regulated. Before it was just personal data. And when it was non-personal data, everybody was happy and we say, okay, it's fine. We can do what we want. Of course, we need to think of IP and confidentiality and so on, but it was different. But now they're bringing non-personal data in the scope, which is also a bit of a mind shift. In the Data Act, you have these odd transfer rules on for non-personal data. It's a bit Schrems 2 madness applied to non-personal data. So it makes it all very complex. So how to deal with it? I think there's a few points. One is to try and deal with it in a holistic way, like assess, okay, what is important to me now, maybe also in the near future, because especially with AI, we see that companies are starting to do things. So maybe for at this point in time, the EU AI Act is not yet relevant, but it may become relevant in 6 months or a year. So address it in a holistic way. That's at least what we advise clients. We also have developed this methodology to address it more thematically, because if you see across all these laws, because they stem from the same idea, from the digital transformation idea from the Commission to make it a safer world, to make it better, to create a data market. So there's themes that come back across all the legislation, like you need contracting terms, that there's transparency and so on. So that's the way to address it, and it will also help, I think, if you create it holistically to create some efficiencies. Another point is I would try and leverage existing structures and reflexes and policies, because many companies have already done quite some work with GDPR, or also sometimes for other laws, for other regulated areas, so to say. For example, if you see a NIS2, there's a whole lot of sectors that come within the scope, but sectors that were already regulated, like for transport and so on. So leverage on that. And then in general, governance is really important, just to make sure that you have the right structures and that you can deal with it, and that you in that way kind of future proof it. But it's not in any way I think, an easy exercise, but you can, let's say, soften it a bit by addressing it intelligently.
Absolutely. I think if you can create a framework, like you mentioned, holistic approach, privacy, risks, security, ethics, compliance, governance, all those dimensions into one, and then apply it and reuse the different aspects of different laws rather than every time reinventing the wheel. Like every law that we have says you should do employee training. We don't have to do a GDPR training, EU AI Act training, and NIS2 training, and so on. So combine and say, let's do a digital trust training, for example. So things like that. And again, in terms of documentation, leverage where you can, rather than saying, let's do DPIA, then FRIA, and then this IA and TPA, third party impact assessment. That's not the way to go. That, and or create bodies, data governance, privacy governance, AI governance. That'll keep you busy, that'll hire more staff, but it won't help you in the long term, because then you'll replicate what we said in the law. There are these laws and they are having a siloed approach. So don't have your siloed approach in your organization, but look at holistic. And that maybe links into the other question which we had in the chat was, what are our views in the panel on efforts to simplify GDPR? Will it help any stakeholders? And I don't know if that's purely in the context of the GDPR, but or also because we know that European Commission has proposed review of the GDPR, and they have looked at some elements like the UK ICO said we should eliminate DPO, and I mean radical thoughts, of course. Not saying we should or I don't endorse, but I'm saying what the news is that the DPO be given to the data protection executive role in a business, the ROPA be eliminated. That's the EC saying, European Commission saying, or news or rumors, let's put it like that. But so both dimensions of simplification in the current sense of it, and simplification that's coming in form of a review. Any one of you want to chime in on what do you think? Will it help? Will it not help?
I can speak to my view, which maybe isn't in line with everybody's view, but my view of GDPR is it didn't ask anybody to do anything that was excessive. It was just general healthy attitude towards using consumers' data. And so all the discussions that we have now, we have nothing really concrete, but removing of the ROPA is a nonsense. It's a fundamental brickwork to doing any sort of gap analysis. So if you look at the reduction that was already systemic in the GDPR as it was, if you had less than 250 employees, you already got a carve out from the record keeping element. So you had much reduced record keeping, but that didn't remove your need to do a ROPA. A ROPA is like, where are my crown jewels? It's an inventory that is fundamentally important. So ROPA's nonsense, in my view, to even consider getting rid of them. DPOs are appointed as, and unlike CPOs, they're appointed as the eyes and ears of the supervisory authority within an organization, so that they're like a mole, for want of a better word. Why on earth would the supervisory authorities get rid of them? They wouldn't. And also, they're the ones who provide the guidance on what should or shouldn't happen with data, and they're fundamentally important. Again, that brickwork. So I think DPOs are fundamentally important. I think what you can do is look at DPIAs. There was a forced review of DPIAs every 3 years, even if nothing happened. I mean, if nothing happened and no changes happened, do you really need to do a forced DPIA review? I think we could have a look at the DPIA process and we could reduce its onerousness. We could reduce the level and be much more clear about what the threshold assessment really is. When does it, you could give some level of give to that threshold assessment. beyond GDPR, we all have pieces of legislation that sit locally in our own states. On top, we have the Clinical Trials Act in Ireland, and that mandates every single piece of processing have a DPIA. It doesn't have a threshold assessment. And so you can imagine that within the context of clinical trials, it's just DPIA after DPIA. And it's nonsense because some of those trials they really relate to so little personal data. So I think that we could visit the DPIA piece, but the DPO and the ROPA, I just think it's silly.
Okay, that's fair enough. So you have given the view of simplification from the dimension of how can regulators simplify the GDPR, but we don't know if that question is in that sense or in general. GDPR by itself is complex, and how do you simplify it towards the stakeholders? Maybe Carrie or Heidi, you want to take that question and say, if you have to make it simplified towards stakeholders, what can you do in the current form of it?
Yeah, it's not an easy question. I've had already many discussions with my team about it, where we were thinking like, "Oh my God, do we need to do another LIA for something?" Or so. But yeah, in a certain way, but I don't know whether it's fully translatable. I like the approach of the AI Act, with really the very clear, tiered approach. But probably, of course, with processing of personal data, it's a bit, yeah, everyone. It's a fundamental right, so everyone deserves protection. But what I liked, and I'm not sure whether it's really doable, and it's a bit linked to, let's say, what we would do if we had a crystal ball, is under the under the directive. I know you had in Holland a transposition law, and under the directive, you still needed to notify processing activities to the regulator. But I recall, and maybe there's some Dutch people on the on the webinar that want to comment on that. I recall that in their act, they also had this system like, okay, if for really the average processing activities that every company is doing, they had these charts and saying like, okay, if you do it for wage management, and if you meet these requirements, you don't need to notify, or there were lesser obligations. And I always liked that idea, but not sure whether it's, of course, very feasible, and it would also need to be tailored a bit to the local national situation. But there's so many processing activities in terms of, let's say, basic security, like everyone has somewhere a surveillance camera at the entrance, and there's so many things that companies are doing, but you need to go through all the steps, even if you say, okay, it's not high risk, and so you can take proportionate measures. But yeah, I always thought that there would be kind of benefits to say like, okay, for these average processing activities, if you meet these requirements, you just need to document that you meet them. So not sure how feasible it is, but it would also create some kind of standardization, because I remember um, under the old legislation, and that was particularly in Holland, that companies like adapted their processing activities to meet the requirements so that they could benefit from the exemption. So in a certain way, it could also shape a bit, I think. But maybe I'm too idealistic there. But I agree with what Valerie said on getting rid of the ROPA. I really have no idea why they think it's a simplification, because even if you would not have that express requirement, and I think you said it also at the beginning, Punit, data inventory, you need to know what you have, because it's really the starting point. Otherwise, how will you do compliance if you don't know what you have? So I don't really understand the reasoning there, and I don't really see the simplification, honestly.
No, I think none of us who understand the GDPR or the privacy laws in essence would agree with taking off the ROPA or removing the DPO, because you can always make the CEO accountable, but they are not the privacy experts, and they would not be able to read the GDPR and translate each and every obligation. And that's why we need the DPO, and that's where the ROPA comes in handy, and that's why the instruments like DPIA are there. But you mentioned the fact about crystal ball, and I like to extrapolate and ask each one of us, if we had a crystal ball. So So I'm not talking what we should not change. I'm going to ask about in this upcoming review that will come up in coming years. What is the one thing we would like to change uh, in this GDPR per se, or and I think Valerie, you touched upon it slightly, but maybe then for you, I will expand it to in the regulatory landscape. What would be the one thing you would like to see changing if you had a crystal ball? Say, I would change this for everyone else, the GDPR, but for you, since you answered broadly touched upon it, the regulatory landscape. And start with you, Valerie, if it's okay.
So, what would I like to see changed? Well, look, the GDPR was written how long ago? Before large-scale automation, before algorithmic decision making. I know that AI has been around. I 35 years ago, God, in my undergrad, I was doing AI programming. You know, predictive analytics has been around for a long time. Machine learning has been around for a long time. But Gen AI and purpose creep, that we create products, that wasn't around when GDPR was created. And I think if it was to be updated, I would like to see it updated to account for content generation, so that we could somehow, I'm not saying have an AI/GDPR, but to actually at least get AI to account for the fact that there is content generation happening. In other words, I can create the most beautiful product in the world and I can sell it, and it's the most compliant product in the world. But what do I do when you, the end user, use it in a way that it wasn't supposed to be used? Because you're going to generate content using it in an inappropriate way. And how do I get GDPR to account for that? I think we can put some obligations on the supply chain. That's what I think we could do in GDPR, is those obligations. All we have in terms of obligations is you have an obligation to make sure that anybody you do business with, anybody you share data with, has got adequate data protection processes in place. But I think we could extend that to more detail in terms of involving bringing in safety by design. So extending that privacy by design piece into safety by design. So how are we incorporating safety by design? I think that's probably the key piece for me that's missing, rather than getting rid of things. I think it's an addition that I'd like to see.
No, that's very well said. I think in this emerging world of AI and quantum, and also the content creation or generative AI, it's necessary to have that factored in and start thinking from privacy, security, ethics, and trust, all by design, perhaps. And with that, if you had a crystal ball, Carrie, what would you want to have in the GDPR changes that are upcoming?
I don't know that I could speak specifically to changes in the GDPR, because it really is at the company's, their level of discipline still is befuddling to me. It is getting more complicated, yes, but they've proven that they're just incapable of just doing regular security, just doing some basic things. So I'm not sure I would like, oh, well, they can't do security, so let's take that out. Like, no, like, what are we doing here? So I'm not sure of exactly what I would change in GDPR. There are two sectors that bother me about GDPR and how they are confounding to other laws in those two sectors, and that is human resources and education. And so when GDPR comes into the employment sphere, data rights all of a sudden becomes really messy, with the company owns it or the employee owns it. And I would love a lot of clarity, because there's a lot of systems that go through the entire employment life cycle, not just in hiring, the whole employment life cycle. And the same thing that happens to a student. in higher education or whatever. So those two sectors, I feel like I just keep GDPR or change it. I'm not sure, but I need a lot of clarity for those two vulnerable populations, students and employees, on what they do and don't own. And before I drop the mic, I would like to just weigh in on your simplification issue coming from the US perspective. You guys are complaining about having one privacy law. Really? We have 12 to 20. I don't even know which way is up over here. So I'm sorry you only have one. I would invite you to come look at ours. It's a mess. So
That's very well said. And you also have some states wherein there's no law. So what do you do? No, but that's very well said, because I think pre-GDPR we were almost in similar situation, and they were saying the ease of business and all, and then they came to this. But let's see. But that wish, if you have to have one law in US, I think that's a bit far off from what we see right now.
yeah, yes.
Not getting political, but they want us to take away the GDPR itself, if I hear it well.
Yes.
So, with that, I think, Heidi, what would be the one wish or the crystal ball thing you would like to see in the GDPR changing?
Yeah, I hinted
Even
to it.
after what Heidi, after what Carrie said.
Yeah, I hinted to it. I would like to explore like this more tiered approach, like we see in the AI Act, to see what that would give. Um,
Mhm.
yeah,
Yeah.
and maybe with some like standardized sets of processing activities, saying, okay, if you do that, then
Hmm.
you're
That's
fine.
interesting. That's
Yeah.
interesting. So you like to have the risk-based classification and risk-based tiered approach of obligations. And I
Mm-hmm,
think,
mm-hmm,
I mean, you make me think probably many a companies you are processing name, email, and that level of data. And we sometimes tend to get into saying, do we need to really do all the stuff on this one? And that can be tiered up, saying that basic elements of data, I won't say exempt, you have the transparency obligation, but don't go beyond a few basic
mm-hmm,
elements. Otherwise, I'll be saying something which anyone would pick on and say, then no, that's not that. But broadly speaking, it's a good idea. It's something worth going deep into. And
mm-hmm.
Valerie, I think you mentioned that you are on the expert panel of EDPB. Maybe that's food for thought for that one when you guys meet
Bring
next
it
time.
back to them. I think
Okay.
it's a good idea.
Yeah.
I actually find it irritating, if I'm honest, Heidi, that that they two are so different in their approach to. I know they're a risk-based approach, but they took such a different approach to the AI Act. I think some of it has to do with the fact that it's not the AI Act is also non-personal data, so they couldn't
Mhm,
keep it the
mhm,
same. But
mhm,
there is something in making the two more aligned to look a bit more like each other. You know that in the case of personal data, these triangles of risk, you know, that if you're on the bottom, it means in the AI Act, you don't have these obligations, and in GDPR, you don't have these obligations. It would be nice to see something like that.
mhm.
Absolutely. Absolutely. Okay. Then I see there are no more questions in the chat. And we've had a wonderful conversation starting with what you think about GDPR. You gave diverse opinions and the significant challenge, and then the inconsistencies and consistencies as we see from within the Europe and outside of Europe, and then getting into the EU legislations, the landscape, the AI world, and what would change in the GDPR upcoming, and what we would like to see in the GDPR changing. So, with that, I would have say thank you so much, each one of you, Heidi, Carrie, and Valerie, for sharing your wisdom, sharing your thoughts, and sharing your experiences openly and transparently, and also everyone else who joined live and who would be listening later. Thank you so much. It was wonderful to have you, and let's continue to celebrate the trust instrument that GDPR is, and let it go on maybe in a more streamlined, more tiered approach, or whatever it will be in coming years. But it's here to stay, that's for sure.
Thank you.
Thank you.
Thank
Thank you
you.
so much.